two matters. The first is an application by Scottish Hydroelectric Transmission plc for Section 37 consent to installed 13.3 kilometre double circuit 275 kV overhead line from a proposed substation at Crewe to the existing Scottish Power Energy Networks 275 kV overhead line that runs from Dalmally to Inverarnan. And the second matter is to consider arrangements in respect of applications for necessary wayleaves in connection with the same line. As I say, my name is David Bouillier. I'm a reporter. I've been appointed by Scottish ministers to consider the Section 37 side of this case. My colleague who's with me at the moment, I'll let her introduce herself. She'll be handling the other aspect of it.
Can everyone hear me?
Yes.
Everybody, nobody hear me? Right, good. My name is Frances McCleary and I'm one of the reporters. As Mr. Bouillier has indicated, I've been allocated a group of wayleaves applications made to Scottish ministers by the same applicants to enable the line, and the decision's been made to consider how we proceed with these together. I've also been put on David's file as a co-reporter, but my function will be to deal with the wayleaves.
Okay, thank you. The purpose of today's meeting, as I say, is to just discuss arrangements for how we will hear the evidence in these matters. There's no discussion today of the case itself. The meeting is being webcast, so it'll be streamed and also available to watch back, which may help with note-taking, etc. And also useful for people who can't be here today. We'll circulate a note of the meeting within, well, certainly next week, that will explain and summarise what we've agreed today. It's also likely to contain a procedure notice, which is a formal invitation. If you want to take part in any subsequent procedure, you need to make sure that you respond to that within the deadline set, which will be 14 days. And that note will go out not just to people who are here today, but also to anyone who has indicated they wish to participate, what we call opted in, which is quite a long list of people in addition to those that are here today. As I say, 14 days is the deadline to respond once that note goes out, to make sure you don't miss your opportunity. Obviously, I'll go into a lot more detail as to what the procedures will be and where we go next. But first, it's probably helpful if I could ask other people who are here to introduce themselves. May I first ask who will be speaking on behalf of the applicant?
Good morning, sir. My screen may say Alex, but that's because I'm borrowing a laptop from SSE for the purpose of the meeting. My name is Marcus Mackay. I'm an advocate in King's Counsel. I'm assisted by my Leonard Jr. Nick McAndrew, who's also an advocate, and instructed by Gemma McMillan, who's a solicitor with SSE.
Thank you. And for the council?
Good morning, sir.
Morning.
My name is Maurice O'Carroll. I'm an advocate in Scotland. I'll be representing Argyll and Bute Council in this matter, and I am instructed by Susan Mayer, Legal Department of Argyll and Bute Council.
Thank you. Who's speaking on behalf of the Community Council? Do we have a representative today? Nope. Okay. And for no more pylons? Sorry.
I'm happy to speak on behalf of the council. I'm Suzanne Anderson.
Right. I know you were speaking for yourself as well.
Yep, and my colleagues Stu and Ishbel are also on the call, but muted. So there's three of us present.
Okay. And they say hello, just have to take a note of their names. Or you can tell me their names, whichever is easier. Just their full names.
Stu Rockcliffe and Ishbel Livingston.
Thank you. We have a group known as No More Pylons, I believe. Who speaks for them today?
That's correct, sir. Good morning. My name is John Campbell. I'm at King's Counsel at the Scottish Bar. I'm instructed by no more pylons very recently, and so some of the links in the chain are not yet crystal clear. However, no more pylons is an informal third-party objector group. It seems to have about 20 members. I don't think it's a subscription group in the conventional sense, but it is, and it's certainly unincorporated. But the instructions that they give me are clear enough for today's purposes, at least. I'm accompanied today by Sue Rawcliffe, who is a guest on this call. The lines of instruction and so forth remain to be clarified, as I've said, and will be laid out in front of you in due course.
Thank you. Are there any other organisations present I've forgotten about? Okay, I won't run through the list of everyone who's appearing on their own behalf, just simply for time reasons. We turn to item 3 on the agenda, which is really just explaining what we'll be doing, or what we intend to do. Section 37 is the Electricity Act 1989 is the consenting process that the proposed line needs to go through, and that's the side that I'll be handling. It is the subject of an objection from the council, Argyll and Bute Council, which has not been withdrawn, which triggered the requirement for a public inquiry to be held, and that's when the file was handed over to Planning Environmental Appeals Division, whom I represent, and my job will be to conduct that inquiry and to report on its findings to ministers who will make the final decision in respect of the application, and how we what type of procedure we take in order to conduct that inquiry. That's what we're going to talk about in a few minutes. I'll ask Ms. McClary just if she could explain on her side of things what her intentions are with regards to the section, to the wayleave process. I think our plans is that they run separately, but in the same kind of time frame. If I can hand over to Ms. McClary.
Right. Well, yeah. I was the group of wayleave applications made by the applicants reached the DPA in the summer. These would be cases where an application has been made to Scottish ministers for the right to use land, and the landowner or the occupier has not consented. So these came in, as I say, in the summer. Of the group that we originally had, quite a few of them have already been withdrawn, and one indeed was withdrawn this morning. So at the moment there are 7 wayleave applications currently outstanding. Now, the procedure for the wayleaves is very different indeed from the Section 37 procedure. They are prescribed by rules made in 1967. Which allow for any person who's affected by a wayleave to ask for a hearing. So far, none of the owners or occupiers of any of the wayleaves I'm handling have actually asked for a hearing. There is one request that may be a request for a hearing, but that requires further clarification. So where no hearings have been requested, letters have already been written to the applicants. That happened earlier in 22. Asking if they would be content to proceed without a hearing. Now, I don't think we have the applicant's final position on whether they're comfortable with that approach, that I should just carry on and work my way through the wayleaves without holding hearings on the basis of written submissions. But the applicants, I think, are in a position either to agree that we go forward on that way, or to ask that we rigorously apply the 1967 rules and appoint a hearing. Now, once it was known that the mainline application was likely to be referred to the DPEA, further procedure on the wayleaves was deferred. So when it was known to everybody that there would be an objection and that the main application would be coming to the wayleaves, we just held back on progressing these. But as I understand the position, and I stand to be corrected if I'm wrong, nobody with a live wayleave application, no objectors with a wayleave application, is participating here today. Can I just ask if I'm right about that? Nobody's got a way leave. Right, now, so here's just one or two remarks about what we do next. As I say, we're very keen to hear the applicant's views on this. The test for Scottish ministers considering way leaves is laid out in Schedule 4 of the 1989 Act. And in summary, a way leave over land may be granted on a compulsory basis by ministers in the absence of consent, the owner of the occupier, if ministers are satisfied that the rights over land are necessary or expedient, these are the two key words, in the context of the operator's statutory obligations and responsibilities. So, looking at Schedule 4 for a moment, this part of the Act is essentially subsidiary. It's a group of enabling measures in Schedule 4. They're quite old-fashioned. In their terms, they're largely unchanged since the origins of electricity infrastructure legislation. The way leaves, in practice, are highly localised matters. The issues are around balancing private and public interest of particular owners or occupiers for a particular section of land. I've done a number of way leave cases for new lines. That's lines coming in for way leaves without permission under the Section 37 or due to Section 36. In each of the cases I've done so far, I've taken the view that until the applicants held final permission for the way leaves, the test of necessity could not be met. Now, I'm a bit unclear as to whether there's a general agreement on that, if you like, from the operator's side as to whether that's correct. Be interesting to hear what the applicants here feel to be the case. That being said, I've found it competent and relevant to take a view and make recommendations to ministers as to whether it's expedient that the way leave be granted now, even though there's not currently a permission. As to the interaction between the Section 37 processes and the way leaves, it's important to bear in mind that both Mr. Bouya and myself are reporters, not final decision makers, and our role is to provide ministers with reasoned recommendations, both of us under our respective statutory frameworks, and that our reports will in due course converge before ministers. So it's just to bear that in mind. If it should be that there are issues of conflict or other interactions between the two processes, the final decision makers would logically be in a position to reconcile any issues, maybe even with further procedure if they feel that's the case. So just bear that in mind. As far as I can see, the most significant potential conflict which theoretically could arise between the Section 37 application and the list of way leaves might be if I develop the view that I should recommend to ministers that any particular way leave should not be granted. And I think we should consider at some point in the agenda, it may even be that you would want to take a view on that and come back to us on it. But we should consider what action should be taken in those circumstances. So again, parking that, subject to that discussion, my feeling is that I see no reason why I should not proceed to carry out my investigations and prepare my reports on the way leave cases in their own terms and on their own merits, separately and in parallel with the main Section 37 process. My feeling is that the way leaves can largely be considered separately from the Section 37 process. It may be that there is material arising from Section 37 application that could be of use to me in considering a way leave. That might happen. I might feel that a query I have about a way leave might be assisted by material from Section 37. But I think I wouldn't want to take any view on that. It would depend on the particular case. But if that should arise, obviously, I would be in a position to raise that query through the Section 37 process. But when it all boils down to is, depending on the outcome of the Section 37 application, in cases where my recommendation to ministers is that it is expedient that a way leave be granted, then the applicants in either process would be unable to implement their way leave rights unless they also obtain their Section 37 permission. So there's that ultimate safeguard. So there you are. That's the complexities of having both way leaves and a Section 37 application. I'm sure that the applicants have thought about the interaction of them, but I don't know whether you want to discuss it further just now. Do you want to discuss it to a conclusion? I think that might be handy. So could I now invite the applicants' comments on my proposals that I just put my head down and work my way through the way leaves?
Yes, I mean, obviously there are quite a few issues that have been raised this morning, and from the applicant's perspective, because there are a number of outstanding way leaves, it wasn't clear as to whether there would be participants this morning who would indicate that they did wish to be represented at a hearing in relation to that process. In light of the fact that it looks as though there are no requests by landowners or agents for hearings, then my initial reaction is that, and I haven't discussed it with my instructing solicitor, my initial reaction is that you would be entitled to go through that process that you've indicated, in other words, to consider the paperwork that relates to the applications. The separate issue, though, as to how that interacts with the Section 37 process, our feeling initially, and it's perhaps something we'd want to confirm in writing, but our feeling initially is that you would want to run that in tandem with the Section 37 process, because as I think you've indicated, there's the potential, at least, for certain issues that may, to some extent, overlap with issues that you'll be considering in relation to the more specific concerns for the way leaves themselves. So yes and no, in other words. We do agree that you can commence work in considering the way leaves, but we'd invite you to do so in tandem with the inquiry process.
Can I just clarify? The 1967 rules are, as I say, from our perspective, they're very straightforward compared to our current procedures, which are a bit more evolved and a bit more user-friendly. And they do appear on the face of them to give a right to a hearing. And in the previous way of doing it, before I think the new appeal rules, was that a hearing would always be set. One would always convene somewhere near the location, and it was up to the landowner whether or not they appeared. I suppose there is a measure of risk that the procedure could be criticised for lack of setting a hearing. Signing what you said, can I just be clear about this? The applicants are quite comfortable that a written paperwork approach should be taken, and there's no feeling that a hearing should be set as a safeguard.
Well, what I think you may wish to do is to set a specific necessary way leave hearing.
Oh yes, I'm not suggesting that. It would be a separate one, yeah.
To deal with this procedural issue, because it's anticipated that discussions will continue with the landowners, and it's possible, at least, that all of the way leaves will be agreed, particularly in the circumstances which have emerged this morning, which is there's no representation in relation to the way leaves. So my own feeling is that it's not wouldn't be appropriate for me to take a position on that matter right here and now. It only just having been raised. But if it is something that is troubling you, there should be a separate meeting to deal with that specific issue in say a month's time, perhaps, when the procedures in relation to the inquiry process are clearer. Well,
I must say, Mr. McCann, that I did actually raise it with your clients. Earlier, I did canvass the idea with your clients, because it's my practice, because of the potential for departure, to absolutely be sure that the applicants in any particular case are comfortable that there be no hearing. So it has actually been raised. I'm not. I think both Mr. Bowyer and myself would be keen to be clearer rather earlier than a month. But I would just say that my discretion, which is a little more limited in the 67 rules, does sit at the background of this, and I wouldn't scruple to just set a group of special way leave hearings, just to be sure that that all the procedures had been followed, if that seemed to be expedient. But I think I think you're, sorry, Mr. Mackay, I think you're right.
Just checking the correspondence that's been passing back and forth, but because I haven't seen. What I would suggest is that we confirm our position in writing within the period that you'd like to set, because I can see why the issue is troubling you and what the potential solutions are. So, as I say, I think if we just confirm our position in writing, that's probably the best way forward.
Very well, very well.
Thank you. Yeah, that sounds helpful. Turning back to the section 37, item 4 on the agenda, I sent a hyperlink to the code of practice that we have adopted, DPEA that is, to or an attempt to streamline or modernise the process that we use for the consideration of section 37 and section 36 applications. So although an inquiry is required to be held, the traditional inquiry session kind of arrangement may, we think, not necessarily be necessary for everything, every aspect, every objection that remains outstanding. And to that end, we've tried to encourage parties to think of other simpler, less time-consuming, more user-friendly alternatives to a formal public inquiry for absolutely every outstanding objection. And that thinking is set out in the code of practice. Some of you will be very familiar with it, others may be less so, but I hope you've had the chance to consider it. And really under item 4 of the agenda is really to ask the question, would you agree that we approach the consideration of the section 37 based upon the DPEA code of practice? Can I ask the applicant first? Be content?
Yes, sir, very much so.
Thank you. And Mr. O'Carroll for the council?
Yes, council is content.
Thank you. Mr. Campbell?
Yes, we're content with the adoption of the code of practice. Thank you.
Thank you. And for the Community Council, Ms. Anderson or one of those, I don't know if you had a chance to read.
We're content. I'll follow on for slightly more educated people saying they're content. So I'm happy to go with that. Thank you.
Thank you. Thank you. That's very helpful. And the idea is it simplifies matters for everyone. So turning to item 5, leading from that code of practice, what we try to do is have an initial stab from the reporter at the issues that might require further procedure and how we might go about dealing with that. It's important to say that if I've indicated that a particular matter doesn't require any further submissions, doesn't mean I don't consider that matter I don't consider it any less important than a matter where I think we need some further procedure, public inquiry or a hearing or something. It just means I think I have enough information before me to be clear as to where the two sides of the argument lie, and so that I can make a recommendation to ministers and confident that ministers will be able to reach a decision on that point. So some matters it's fairly clear where the parties stand, and I think we've got a lot of information in writing. So in those cases, I don't think we need further procedure of any sort. There may be other matters where I think there appears to be quite a clear difference of professional opinion, and it would be helpful if those professionals had a chance to explain themselves and to be subject to cross-examination, so that I can be confident that I fully understand where the differences lie and I can advise ministers accordingly. And again, other sessions, perhaps there's more down to issues of interpretation, for example, where a more streamlined process might be a round the table discussion in the form of what we call a hearing session. I'll explain the differences in due course. So I set out a very preliminary idea of where I thought, having read through the correspondence, we might need to go in terms of further procedure. I would say I did that prior to reading the council's position statement, which we had recently, which may well have clarified one of the points, and I'll come to that in a minute. But first matters is very often the case with cases under Electricity Act, is landscape and visual effects. There's a clear difference of professional opinion, which, as I say, is one of the sort of triggers where I would really want this to be dealt with in a formal inquiry session. I'll run around the table to see if anyone has any objections. So, first question to the applicant, Mr. Mackay. Any disagreement with the landscape and visual being inquiry session?
Not really, sir, but I think it would be worth giving a little further thought to whether a hearing session might be appropriate for that topic.
Okay.
And I say that because, unlike many Electricity Act applications of this nature, for this particular inquiry, the landscape and visual issues seem to me to be relatively contained. They mainly relate to the impacts in and around Dalmally, and the only specific issue identified by the Planning Authority, which is the impact within the area of panoramic quality, in particular from the Duncan Ban Monument. So it seemed to me that the scope of the issues between the parties would be relatively narrow and probably less technical than is often the case. So although it's anticipated that there would be 3 landscape architects who would want to contribute to the discussion, it seemed to me that a hearing might offer a good opportunity to focus that discussion, and also perhaps would be more user-friendly for other parties who wish to participate in that session. So it's not a complete disagreement, sir. It's just floating the suggestion.
Yeah, no, that's helpful. Thank you so much. Mr. Carroll, did you have any views on that from the council's point of view?
I've had a chance to discuss that with Mr. Mackay, and my position is a general one in principle that I have, is that in this matter it is quite a central issue, and is one normally best dealt with by way of an inquiry session, so the matters can be fully aired. Appreciate that we can say it's narrower than it is than LVI issues would be at large normally, and think that I'm sure that's correct, but it's hard to fully consider in advance of hearing the actual evidence itself just how wide it might be and to what level of discussion it will then ensue. So as a matter of general principle, I would prefer that the matter be dealt with as you suggest, so by way of public inquiry. Reasons I might come to that might alter, but that's my initial position as a matter of principle. Thank you.
Thank you. Mr. Campbell, do you have a preference?
Yes, we agree with Mr. Carroll. I'm a little puzzled by the applicant's position. They seem to be undecided. This is clearly the primary issue in the case, and there will be a landscape architect appearing with the third-party group. Experience suggests that these matters do become refined as you get closer to the date of the inquiry, and that an inquiry itself needn't necessarily take up that much more time than a hearing. So the clear preference of the group is for an inquiry session. However, if you decide that it should be a hearing session, I'm sure we could make a contribution as well, but in a slightly different way.
Thank you. Thank you.
Sir?
Does the Community Council have a preference?
Hi. Obviously, my role on the Community Council is to not represent just my own views. I'm a member of the community, but represent the views of the very broad community that I was elected to stand for. And it is one of the central issues and concerns for the community. So I would echo that a public inquiry would be what we would want and what our community would hope for. I think that's fair to say.
Okay, thank you. That's helpful. But I understand why Mr. Mackay was heading in the direction of a hearing, because it can be easier for members of the public to engage in that sort of format. It's less daunting, I think. However, I think I am minded to go for an inquiry session simply because of the, as Mr. Mackay said, there'll be 3 landscape architects of differing opinions, plus local people who know the area better than anyone else. I'd like to think to have that very thoroughly investigated. It might be that in advance of getting too far down the preparation of evidence, we could, the parties could come together in some sort of statement of common ground or a statement of agreed matters to try and agree that, as Mr. Mackay said, what we're talking about in terms of landscape and visual effects, the scope of it, if parties can agree that we're looking at relatively localised Dalmally and the monument, and just to try and reduce the amount of ground we need to cover. But subject to that, I think we are going to have to go for an inquiry session on this one. Did you want to come back at all, Mr. Mackay? Are you content with that?
Nope. So,
okay, thank you. Now, the second matter where I indicated, and I said this was before the council's position statement, we might need a formal inquiry session, was the issue on effects on the historic environment. I came to that conclusion based upon reference to the specific supplementary guidance relating to listed building setting that the council had included in its objection. So I was unsure as to whether the council's concerns with the monument were its cultural heritage value, its effect on its setting, etc., or whether it was more, as I think I came possibly round to the conclusion when I read the position statement, it was more with the monument as a visual receptor and people going to visit the monument and how they would see the thing as part of their experience of the visual environment rather than specifically as a part of cultural heritage. So I might be completely wrong on that, and I'm looking at Mr. Carroll really, I think initially just to give me a clearer picture as to what the council's position is, and was it intending to lead a witness on cultural heritage, historic environment matters?
So the position statement, as you've correctly noted, sets out the council's position. Also, I'm looking now at the minutes of the committee hearing on the in September of last year, and it is the latter, I think, of what you suggested, that being the question of it being a receptor, a particular receptor, rather than being a matter of cultural heritage in itself. Just even to short circuit matters, to make it clearer still, it is not my intention to lead a specific cultural heritage witness.
Thank you. That's very helpful. Mr. Mackay, did you have a view? Was it your intention that you were desperately wanting to give me a listed buildings witness?
Only if you required one, sir. My reading of the council's position statement was the same as yours, and in fact I raised this issue separately with Mr. Carroll, and it seems to me that not only does the council not have an intention to lead any evidence on cultural heritage issues, I can't see that any of the other participants at the inquiry have a similar intention. I may be corrected in that, but that's my understanding at the moment. And in fact, because of that, my suggestion was going to be that if you required additional information on cultural heritage issues, that should be done by way of exchange of written submissions. There's also, I should say, a practical issue in the sense that there's been some discussion between parties, the main parties, I should say, about potential dates for sessions, oral sessions, and the dates that are best suited don't actually suit the witness that we would have been intending to use for the cultural heritage aspects. So, as I say, my take on it is that if there needs to be additional information and you would wish additional information, then written submissions would be the best option.
Thank you. Mr. Tremble, do you have a view?
Yes. Being recently instructed, I haven't explored the availability of a cultural heritage witness or the resources to fund one. However, I shouldn't give evidence, but I have personal experience of this area in the world of wind farms. And I recall at the Upper Succoth wind farm inquiry, which was some years ago now, the landscape and visual impacts sort of embraced the cultural heritage of the area, particularly in relation to this monument. And so I think it's unlikely, but I would just put a slightly tentative expression, a slightly tentative mark next to that. I think it's unlikely that we would try and find a cultural heritage witness in the conventional sense, and that we would make do with landscape, with the landscape assessment, so far as that might bear on any cultural artifacts or other cultural heritage. It's important to understand that this impact of this development is a little wider than the village of Dalmally. well, sorry, a lot wider. We'll do shot before I start. A lot wider than the village of Dalmally. And so we've got to look a little further afield to see just what the cultural heritage impacts are.
Okay, thank you. That's helpful. I'll turn to the community council. The issue we're trying to address really is we're not ignoring obviously the effects on the monument, which is a listed building. It's whether the basis for people's objections or people's concerns about the effect on the monument is to do more with what visitors to the monument will experience, or any loss of that experience or any effect on that experience, rather than any effect on the monument as a listed building. It sounds like splitting hairs, but it's relevant to the procedure we adopt as to whether we have specialist listed buildings witnesses, or I think the parties are generally in agreement. What's required is more to talk about the landscape and particularly the visual amenity effect for people visiting the monument and what they will see. So the question really was, do you know if the community council's concerns are specifically about the effect on the setting of the listed building as a listed building, the monument I mean, or is it more with visual amenity, what the effect that people will see when they go to visit the listed building? If that's an answerable question, sorry, it sounded rather garbled. Yeah. Does that make sense?
No, it does make sense. So from my perspective, based on the feedback that the Community Council has had over years, because this has been going on for a very long time, yeah, I would actually say it's both. And this is a very diverse community, and people's experience of the landscape and our connection to the landscape and the history and the heritage, it's diverse as well. So I would probably be led with the direction that Don Campbell would like to go, because I think he probably appreciates the splitting hairs more than I do. So, and I think when we have had community discussions about what our objections are, those were not things that we split hairs over.
No.
So I think I would like more time to maybe even gauge and define exactly what our objections are. You know, we are not a single entity, we are a community, so that is not something that we've actually narrowed down. So I'll be led by John, but also I can get more time to clarify that if possible. Well, I think John has his hand up.
He does, yeah. Mr. Campbell, you'll just come back.
Thank you very much. I just wanted to underline that although my instructions are recent in date, I'm making an effort, as I often do, to try and bring as many people under one umbrella as possible. And so I'll be having discussions with Ms. Anderson in the fullness of time to see what her ambitions are for this inquiry, whether they coincide with not more pylons. Of course, I'll let you know. I've already discussed this with the staff at DPEA just very shortly, and I'm hoping that's been passed on to you.
Yes, thanks, Mr. Campbell.
Thank you.
Was there anyone else present today who had a view as to whether we need to have some sort of oral process, particularly an inquiry, to deal with the listed building issue in relation to the monument? No one else got a view? No. Okay. Well, I'll have a little think about it. I'm certainly not minded now to have an inquiry session. I think the question will be whether I need more written submissions on that listed building issue. I'll have a proper read through the representations again that members of the public have made, and I appreciate the Community Council's point that people don't define their concerns neatly into one box or another. You know, it's more broad ranging. So I'll have a good think about whether I think I've got enough information on the effects on the setting of that listed building, and come to a conclusion as to whether I need further written submissions. Mr. Campbell, on your point about broader effects, I don't know whether you were talking about landscape and visual effects or whether you were talking about effects on other cultural heritage assets, of which there are quite a few. Can you clarify that? I think you're on mute, Mr. Campbell.
I was trying to talk about landscape and visual effects, not on the wider cultural heritage, but because I simply don't know at this stage.
Thank you. Okay, well, because as I say, there are other cultural heritage assets which have been looked at, and some have raised some concerns about them. And we have the views of various statutory consultees and others. So I feel like I had enough information on those. My question mark was only about the Duncan Ban monument. So I will have a think, and I'll confirm in the note of the pre-examination meeting, which will come out next week, whether I think we need further written submissions. But I'm confident that we won't need to have some sort of oral process on that from what you all said today. So moving on to issues where I thought we might need a less formal hearing session, so around the table discussion led by me. The first of those, and this arose out of really objections from local people rather than the council itself, but whether the consideration of alternatives was adequate. And I was indicating this would be a hearing session to consider that. Mr. Mackay, does the applicant have any objection to that?
We're content with that, sir.
Thank you. Mr. Carroll, council?
Content with that also. Hearing session for policy matters dealing with alternatives and other guidance.
Thank you. Campbell?
I don't think you're taking these 3 bullets as one.
Well,
the consideration.
You may have other bullets, Mr. Campbell, I know, but
Well,
we'll just take the first one first, the alternatives. You can take the
I may just deal with them in the sequence you've set them out. I agree with you that a hearing session on the consideration of alternatives is probably preferable. So I have no objection to that. But I want to emphasize that it is a live issue for, at least for the Dalmally population. So far as the second bullet is concerned, if you could be persuaded to widen it, to look at questions of need and compliance with policy, then we haven't taken a view yet about whether it would be preferable to have that discussed as a need, as an inquiry issue or a hearing issue, but it seems the logical place. Since my instructions do include a wish to consider the need for this line at all, which is a general macro question, a strategic question, this seems like a logical place to consider it. If you were prepared to widen the bullet point just a little to add the words need and, or need for the line and, or need for the project and policy compliance, then I'm quite confident it could be comprehended here. And clearly in relation to the last bullet point, a hearing is appropriate.
Thank you. Community Council, so my proposal is that we discuss whether the consideration of alternatives to the proposed scheme has been adequate, to discuss that in a sort of roundtable, less formal but still structured discussion, where essentially I'd be asking the participants questions and they'd have the chance to respond, and through me possibly to ask questions of other parties. Are you happy with that being the right approach to the consideration of alternatives?
Yes, I think we are happy with that, and we're also happy with the point that it should be the discussion of the alternatives and for the project as a whole. So okay. We're happy with that.
Okay, so that's the need point that Mr. Campbell
absolutely
raised. Yeah. Mr. Mackay, does the applicant have a view on whether we need a session on, and then what sort of session it should be on the question of need, and should that be tacked onto a policy session, or should it perhaps go with the alternatives, or should it be a standalone, if indeed there should be one?
Well, I think Mr. Campbell's point may only be 2 little words, but it seems to me to sit not very comfortably at all with that session.
Is now joining.
And it's really a separate issue altogether. You'll understand that the applicant's position in the position statement was the issue of need does not the face of it need to be the focus of this inquiry for reasons that were set out in the covering letter. If you feel, sir, that in light of the position adopted by No More Pylons, then you require more information on the technical justification for the project, and the applicant's very happy to provide that. The mechanism for doing that, I would suggest, should be a way of written submissions, and there are three principal reasons why I would suggest that would be the appropriate way to handle that part of the inquiry if you feel it necessary to have additional information. One is that in my submission, it wouldn't be necessary or indeed appropriate to seek to revisit or challenge the separate regulatory process driven by Ofgem in relation to the initial needs case, which was submitted and indeed was approved by Ofgem on the 15th of December. Mr. Campbell's clients have had the opportunity to participate in that process, and indeed will have further opportunity to participate if they wish in the application for the final needs case when that's submitted. Secondly, as you're aware, sir, NPF4, which is to be published on Monday, as I understand, it establishes the in-principle need for the project as a national development. And that seems to me to be an important consideration, which is different perhaps from previous inquiries. And thirdly, it's really a practical consideration in the sense that the technical justification for this project and how it relates to the strategy, the wider strategy to upgrade the network in this area to 275 kV is very technical. It's something that actually, in my view, at least, it's so potentially complex in terms of the technical parts, the technical components, that the clarity of the written word is actually favourable. So for those reasons, if you're satisfied that there is a need for further information on these aspects, I would invite you to require an exchange of written submissions on the topic.
Thank you. Ms. Campbell. I can hear you.
Sorry, my learned friend Mr. Mackay seems to be talking himself into an inquiry session on the need for this line. Although there is indeed an Ofgem consent in place, it isn't a final consent, and it didn't cover the question of route. And so when we talk about need, we have to talk about route as well, routing as well. Now, as he rightly says, this is a complex matter, not in my submission best dealt with on paper, because the opportunity to deal with issues which arise on paper is just not there, and you end up with an exchange of communications in writing, which is just like a game of ping pong. Were I coming to this with better information in front of me, I would be able to perhaps argue for an inquiry session. But seeing where you have put this, it seems to me that a hearing session would meet the case. There's lots to be said, as I'm instructed, about the need for the line in this location, the proposed line in this location. And if you were to add a fourth bullet point here, then in my submission, that would meet the case. It would meet the case economically, because it isn't likely to take a great deal more time. Some more time, of course, but not a great deal more time. If there were an inquiry session on the strategic need for the line in this location, then we might be talking 2 or 3 days of inquiry. And I'm sure that wouldn't fit with the general desire to have an economical process. NPF4 is not the last word on this or any other development. It's quite true that it's characterised generally as a national development, but it's not characterised specifically in that regard. So those are my thoughts at the moment. A hearing session on need. Hearing session on need seems a good middle of the road solution to what is required here.
Thank you. I'm leaning towards Mr. Campbell's position, I have to say, just because because of its technical nature. What I don't want is for an exchange of correspondence to throw up other questions which I may have because I don't fully understand where the two experts are coming from, and because I can't preempt the matter and conclude, as perhaps the applicant would like me to, that the boxes have all been ticked by NPF4 and the INC. I may have questions. They may be naive questions, but I suspect I will have questions because it is a very technical subject. And I think to try and do that by a series, what could be a lengthy series of backwards and forwards in writing, I think I'd sooner have the experts around a table who can tell me where I'm wrong or why the other side is wrong. So I'm certainly minded, I think, to have a hearing session. As Mr. Campbell says, I'd rather avoid an inquiry session because I'd hope it can be quite a focused and relatively speedy process of arriving at the answers I need to give ministers. Mr. McKay, you have your hand up. You come back.
A couple of issues, sir. Seems to me that at least part of what Mr. Campbell was talking about was not really to do with the technical justification of the project at all. It was to do with the project alternatives, routing issues, which are already the subject of the alternatives part of the hearing session component of the inquiry. The second observation, sir, is that your own thoughts perhaps anticipate that there would be competing expert evidence. At this point in time, as far as I'm aware, there is no expert competing evidence which might be more suitable to a type of oral debate or oral discussion or cross-examination or so forth. So it may be, sir, that on reflection, once you understand exactly what No More Pylons and others are asking you to consider, that you could, so it's a matter of you, sir, but you could invite an exchange of written submissions in the first instance, and then having reviewed the paperwork, take a view on whether it's necessary to add any additional points to the hearing sessions dealing with the issue of the technical justification of the project.
Yeah, no, that's even more attractive. I think Mr. Campbell and I have had a session recently in the south of Scotland dealing with this, a very similar issue, sort of technical and economic justification, at which that particular community group did have an expert witness, and I'm kind of that's perhaps influencing my, and perhaps wrongly, my assumptions as to where the evidence might go. It may not be the case that we're in that position with this very different proposal. It was a very different Section 37 case. Mr. Campbell, that sounds sensible, does it? That we initial exchange of written.
A preliminary, what do you call it? An outline statement of case or a preliminary statement of case? Can you hear me all right? Yes. Indicating where No More Pylons wants to go with this before finalising your view on the form of any inquiry. If we don't come up with something sensible and capable of discussion, then there won't need to be anything at all. And that would be without desirable in terms of economy, but it may or may not reflect the community's views. I think I have to be satisfied that there is a stateable case to advance before I can simply say, without any ambivalence at all, that we will be making a case on need. I have to be satisfied that that case has some merit that I can put to you.
So if I could interject for the council, it seems to me, though, that if ultimately there is to be a hearing around the question of need, it's something that has to be decided upon today, because we're setting down the duration of the inquiry today. And if you subsequently decide, having limited the inquiry to, say, 4 days, that will require extra time, then it will be very difficult to then create that time later. I think it's maybe a decision that needs to be arrived at today. It seems to me that, from my own point of view, I've only discussed this matter fairly briefly with my planning consultant, but it's certainly something that I would anticipate might be addressed by his evidence as part of that hearing session dealing with alternatives and so on. So I think it might be prudent just to simply set aside the time for that now, and then to leave open the possibility of a hearing session on that matter.
Yeah, no, once we've arranged a certain slot, it's very hard to then extend it by a day or something, because the slot tends to be the most we can actually find. Would there be merit in identifying an extra day of hearing now, which we may or may not need, depending on, and we'll set Mr. Campbell a deadline for his side to come up with submissions, and then we'll decide if we need that extra day now. Would that be possible? So it would have a standalone session of a day maximum. I'd have thought you can get through a lot in a hearing in a day.
Mhm.
And then if we don't need it, we don't need it. Because there's inevitably some run over. It's nice to have a venue booked for an extra day and witnesses just in case we need it. But if we don't need it, then so be it. Yes.
Sorry, from the community council perspective, I've only been an elected council member since last year, but I have been attending the sessions from SSEN and previous council and No More Pylons for years now. In terms of our preference, we would be happier to have that day set aside, because I think we need to recognise that the community council, we're just ordinary people. This is quite it's a very formal procedure, so we want to make sure that we do our best at it. And I would say that one of the things that the community themselves probably feel is that in the past our written submissions haven't always given us a sort of equitable hearing of our statement of case. So I would personally and from the council prefer to have that day set aside, with the understanding that it's an obligation on ourselves to make that day possible and worthwhile. And I think that's what the community would expect and appreciate on that matter.
Okay, yeah, thank you. That's helpful. I mean, I think the question will be if you have an expert, for want of a better word, witness to address what is likely to be quite detailed technical evidence, then that would be worthwhile. But I wouldn't want any members of the community to feel that they wouldn't have the chance to have their voice just as a local person heard, which kind of leads me on to what I was going to come to next about a less formal evening session where people can actually come along and explain in their own words what their concerns are across the whole spectrum. So not a sort of technical discussion with experts, but local people explaining to me what their local perspective is. Before I come to that, just for my own clarification, I think we agreed we will need a session on alternatives. We will need a session on policy, again, hearing session, and a session on planning conditions as per usual. I think we all agreed that, and we will, subject to what Mr. Campbell discovers and where he wants his case to go, etc. We'll set aside a day for a hearing session to deal with the need justification type of question. I think we're all agreed, unless anyone shouts no. Okay, which brings me back to this idea of an evening session. Clearly, I've got lengthy written representations from members of the community, which I've read and are very helpful. But it is often quite useful for members of the community to come at a convenient time, usually in the evening, and explain precisely what they mean and just in their own words convey the strength of the feeling, etc. And I'm very happy to arrange that. The idea of that would be there'd be no cross-examination. The applicant may want to have somebody there to answer any questions that arise, but essentially it's more to give people the opportunity to say in their own words what they've already told me in writing, just so they can make sure I fully understand it. And I may have questions just to understand where they live, what their experience is, why they use a particular part of the landscape, etc. So my plan, I think, as set out in the agenda, was to have that as an evening session. It'd be some point during the inquiry week. Probably quickest to say, does anyone have any problems with that? No. Good. Okay. Well, we can set aside some time one evening for that. For every other matter, and obviously the environmental. Yes, Mr.
Sorry, you beg your pardon. You've emphasised that there would be no cross-examination of any local people who wanted to turn up. Mm-hmm. Just on recent experience, that worked very well in Dumfries and Galloway recently. Although the reporter had many questions, I think, and she did ask them as we went along.
Yeah, people need to come prepared to answer questions. There shouldn't be any trick questions. Just for somebody who doesn't really appreciate the geography, the locality, there may be questions from me as to why do you say that? What does that mean? Where's your house? You know, simple stuff like that. But not. It's designed to be non-intimidating as far as speaking in public can ever be. It's designed to be non-intimidating kind of evening session. And yeah, I think they usually work quite well.
Can I ask a
yes.
question about the evening session? Is this going to be in person or is this going to be perfect?
Yes, definitely in person.
I mean, my goal in preparing for that would be to ensure that the community understands some of the splitting hairs that you have explained to me today, sir. And I think, you know, I'm happy to be on hand to support people giving evidence, make them more comfortable. I don't mind public speaking, so I think the community are really happy with that opportunity. I think they're really grateful for that opportunity, and for it to be in person is just fantastic.
Good. Yeah, yes, definitely in person. I'm no fan of this type of thing, I have to say. I mean, it makes a lot of sense for this type of meeting, procedural meeting. It would be crazy for us to trip around the country. But for something that's dealing with actual concerns that people have, it needs to be in person, and we will be there anyway. So that's what we'll do. Other matters. So everything else that the applicant's team has looked at in the environmental impact assessment report at great length, and I've had the comments from local people, comments from consultees, the views of the council as set out in its report of handling, etc. For all of that, I think certainly at this stage, I have sufficient information before me to be able to make recommendations to ministers. But was there anything anyone thinks is missing from my list of matters requiring further procedure? No? Good. Okay. I stood item 7, brief explanation for those intending to participate in what an inquiry and a hearing is. I will keep it very brief. The hearing session is a round the table discussion led by me. It is not it's not like a public meeting where anyone can chip in at any time or members of the audience can get involved. You need to have indicated in advance that you want to take part in the hearing and provided a written statement of what you intend to say. And that's the interests of fair disclosure for other parties. So it needs to be structured and led by me. There's no cross-examination, but it might be that through me, one side wants to ask a question for clarity over the other side. So I wouldn't say it was informal, but it's a lot less intimidating than a full-blown inquiry session, which is the other technique we'll be using, where again you have to disclose your evidence in advance, and the difference being you will take the witness table and you will read out your evidence and then be potentially subject to cross-examination by the person representing the party of the opposing view, which some people can find more intimidating, etc. And as I say, in this case, it's usually limited to technical evidence where you're appearing as an expert rather than as a representative or a local resident. So that's the difference. It's a bit more of a grueling procedure designed to get to the very bottom of the professional evidence and root out where differences of technical and professional opinion lie. And then the final session, as I say, is the informal evening session, which is designed to be informal. But again, it's not, I stress, it's not a kind of traditional town hall meeting where people like to chip in from the audience. It will still be one person will speak at a time. I may have questions of them. They will need to have set out in advance what they're going to say. And it may well be that the letters of objection they've already submitted are sufficient. That you know, if that encompasses all that they want to say, that's fine. They can just confirm that's what they'll be speaking to. But it's a much more informal session, and obviously designed to run at a time when people can make it. So just see where we're up to next. Yeah, I suppose the other point, just in terms of procedure, was if there are matters that parties can agree amongst themselves, the statement of agreed matters in advance of the oral procedure kicking off can be quite helpful. Similarly, agreed conditions. There will be a conditions session which deals with the possibility that ministers may want to grant consent. Doesn't indicate by having that session that I've made any conclusions in that regard. It's just purely to deal with that eventuality. And if obviously parties can get together and discuss what might be appropriate conditions in that scenario, then it makes that session a lot less tedious than it can be. So again, I'll set out in the note of this meeting what I would hope would happen in that regard as well. Item 8 was dates. My ears pricked up that I hear that parties very kindly have been having some discussions on that. Can I ask the applicant first to kick that off?
Yes, thank you, sir. Partly because of the complexity of piecing together everyone's availability over multiple parties, we tried to do that in advance of today. Initially, the applicant had suggested dates in mid-April and early May, but it transpired that that wasn't suitable for various reasons. And that led to reconsidering what would work for everyone, if you like. And the date which has been identified, obviously subject to your own views, sir, is the week commencing 19th of June, which, as I say, is much later than the applicant had hoped for, but would still be before the summer holidays. In terms of how long would be required, I think given the discussions we've had this morning, I think probably we're looking at about 6 days. Possibly that would be allowing for a day that might not be necessary, but I think probably 4, 5, 6 days is what we're needing to have set aside.
Okay, yeah.
And I say the one caveat to that was that the cultural heritage witness that the applicant would have used at an inquiry session is not available that week, but otherwise that week suits the applicant.
Thank you, that's helpful. Before I ask the other parties to chip in, does anyone have any objections to sitting on Mondays and Fridays? In other words, could we deal with it all in a week, plus maybe the Monday is the overrun, which we might get away with not needing? I know, I appreciate it involves eating into weekends, etc. And I wouldn't impose that on anyone if it causes a problem, but does anyone have a major problem with that? No.
I don't think so, thank you.
Thank you, that's helpful.
I think most of the point, I think if it's going to be an in-person inquiry, it's far better that the days are consecutive.
True, yes, travelling wise, yes.
Yeah, absolutely.
I agree.
So week commencing the 19th and then possible overrun onto the 26th if we need that extra Monday. I'm just my colleague, because we don't know if what is going to go on with, we might need some sort of oral process to discuss way leaves and how that would fit in with that and whether that could, should, ought to take place at the same time. Jerry, have you got any thoughts at this stage?
Well, I did say to Mr. Mackay that we were keen to resolve matters a little bit more quickly than he suggested, but in fact, I think the best thing to do would be to lay out in a written explanation again the potential snags that could arise from the way leave process. I was rather thinking, first thing we need to establish is whether the applicants are comfortable that I should proceed without holding hearings. And if they are comfortable that I should proceed without holding hearings, I think I would just be commencing work on them. The situation with the hearings is that very few of the objectors to the hearings have given anything substantial to say what the nature of their objection is. They have been reminded that matters of compensation and accommodation are almost always irrelevant to the process of the way leaves. So I don't know what is leaving the way leaves open from the objector's point of view, and I don't know what their substance of their cases are. Given that I haven't said that so far, despite the fact that the cases have been live since summer, I would be inclined to think, as I say, that I would just begin to work on them.
Sorry, can I interject? Would it be helpful if myself, as representing the community council, and these are all members of my community, would it be helpful if I got in touch with these people and just confirmed that there hasn't been any substantial reason that they haven't got in touch and given you any more information.
And well, it's always helpful to have somebody assist with organising members of the community on the ground. That being said, as I said at the outset, the waves are really kind of private matters. They're all about impact on the actual landowners. And in those circumstances, I'd hesitate to ask you to do such a thing. You might find yourself getting into, being regarded as being intrusive. I may be quite wrong about that, but I think the important thing is to bear in mind that these are all about the impact on people's private circumstances. So I would, and thank you for the offer, but I think probably just the best keeping on writing to people. I may say quite honestly that the Wee people do actually have professional representatives.
Yes,
they are represented in one form or another.
Could we say, assuming the absolute worst case scenario that somebody did want to come and speak in respect of wayleaves, would that Monday be, in terms of your diary, would that be a possibility?
The
26th.
The 26th. Yeah, so that would be fine for me.
So maybe that's the. Yeah, I'll come to the venue in a second, but it might be we could, if we needed both sessions, we might be able to have both sessions running on the same day.
I mean, I do say I'm coming across as if I'm wanting to expedite things perhaps more than is seemly, but I must say one of the options that did occur to me was that I set up a Wee Leaves Day, and it could be earlier than June, and give people the opportunity to appear sequentially somewhere locally, if an oral hearing was what the applicants preferred, and there's continued to be no view from any of the objectors. But if if the 26th looks the most rational solution, that's certainly fine by me.
It does sound like you might be in a position to know if it's going to happen or not long before then.
I would hope so.
I mean, maybe setting a day where you go and sit there and see if they actually turn up. That wouldn't be the first time that's happened.
It sometimes happens.
I don't think that needs to worry us too much. Either we'll have that 26th for something if we need it. So turning to item 9, the venue, the community centre, I've had good feedback on from a colleague, and it seems the logical place to go. Does anyone have any? Does anyone have any knowledge as to its availability, which I haven't inquired obviously yet?
Which community centre is that, sir?
In Dalmally.
We would love to have you. We would love to invite you. It's a massive big space. I believe SSEN are quite familiar with it as well. So yeah, we can. There's several people on the call that are involved in the community centre management, so we'll make sure that that's available for you.
Brilliant. Mr. Campbell, were you saying something? Yeah, Mr. Campbell.
Yes, I was instructed to make the same offer. So it's Miss Sanderson-Scott's ahead of me, but apparently it's available and it has the internet, and I have been there for an inquiry. It's a very good venue.
Can I ask, does it perhaps have smaller meeting rooms?
There isn't.
Yes, there's a smaller meeting room. The meeting room is quite small, but there is one. And the hall itself is very well appointed.
Yeah, well, the Wee Leaves probably don't need the big hall. Would it be good if there was a bit of consistency about it?
I think the smaller room could comfortably sit sort of 12. And it is very private as well, so you can quite easily separate the two out.
That's our venue then, by the sound of things.
Yeah, it sounds good. Ms. Rawcliffe, did I see your hand up? Come down.
Her hand was up, but I
was just going to say that it does have smaller meeting rooms, and it has a smaller meeting room, and it has internet access as well, so that might be helpful.
Yeah, yes, that's always useful. Thank you. That's very helpful.
Internet access is crucial. I've been at a community centre in the past and other inquiries where to set up a separate Wi-Fi system itself just for the purpose of the inquiry, but it sounds like that won't be necessary, so it sounds excellent.
It's got good Wi-Fi and good 4G signal as well, so you can make and receive calls and things in there.
Ideal. Well, the office will be in touch with the community centre to sort out all the details of that. So in terms of housekeeping, it sounds like we will be sitting Monday to Friday. Sitting times usually 10 till 5-ish. We're running behind. We might start slightly earlier, but we tend not to. The evening session we would usually start at 7:30, if that's convenient. But again, we could sort all those details out nearer the time. In terms of site inspections, generally we would do unaccompanied site inspections as a matter of course, but quite often parties would like us to look at particular things, particularly local people want us to look at something from a particular location. Usually we would sort out where we might be going, so an itinerary for that during the course of that inquiry week. So I think we could deal with that nearer the time, but maybe people can have a think about if there are any particular places that they would want us to go, or certainly Ms. McCleary's concerns would be with any outstanding objections to wayleaves. My interest will be in the full range of locations identified in the EIA report. So if it's in, for example, the landscape and visual impact assessment, I will be almost certainly going there as a matter of course, but I'm happy to go again if people want to accompany me there. I stress the process for an accompanied site visit is not an opportunity to give evidence on site. It's merely just physically to point out the location of things. This is my house. This is this view I'm interested in, etc. But we can talk more about that, as I say, during the inquiry week. But I would hope that in advance of the inquiry, I will have been to the locations I think are important, so I know firsthand what we're talking about in the sessions. Item 11, I think it is. Oh no, I seem to have missed out item 11. That's good. Item 12. Relative of guidance. I wanted to just flag up. We have a series of guidance notes for reporters, of which number 23 is titled "Managing an Efficient Inquiry Process." So it's really just some sort of commitments we've imposed upon ourselves to try and keep things rolling along. But it also has implications for any other participants. It's really just common sense things like please respond to things by the deadline and make sure you copy everyone in. I've been told to stress the importance of Objective Connect, which is a system that I'm sure a lot of you are familiar with. I think the Scottish courts use it. It's a means of sharing one copy of a document. So you will all be given a link to upload any documents to which you wish to refer, and ensures that everyone has access to the same source document, so there's no confusion. Some documents, core documents, are almost certainly already in our possession. It may be that a link can simply be provided to those. But the idea is there'll be one source of all the documents, and parties probably best advised to download a copy of that onto a memory stick or something for use during the inquiry. Despite the fact that it sounds like broadband isn't too bad, it's always wise to have a backup just in case. But further explanation of that will be given by someone who knows more about it than I. But I was asked just to stress that rather than the old days where we're printing things out and posting them to each other and all of that, it's designed to be primarily electronic. Obviously, certain documents such as visualizations need to be in paper copy, and I have a copy of that, for which I'm very grateful. And we will need the council to provide, I think, a hard copy at the inquiry and hearing sessions for members of the public if they want to actually physically get their hands on the documents. Anything else I haven't missed? Oh, the case officer for the Section 37, if you haven't come across it yet, is Karen Cowie, and the officer for the wayleaves is Morag Smith, and their contact details will be put in the note of this meeting. You'll be able to view the recording of this meeting again pretty much instantaneously. I think within a few minutes. I think of it ending, it's pretty quick, but certainly by tomorrow. The note of the meeting I'll get out next week. It'll set out what we've agreed, and obviously, if there's any questions about that, you can come back via the case officer. And that note, as I said at the start, will incorporate what's called procedure notice, which is a formal mechanism that we use for inviting responses to say, yes, I am going to participate in the following sessions. It's kind of, now's your chance to indicate that you want to participate, and we give a deadline of 14 days for you to do that. So you need to make up your mind now as to if you want to do that. For those who are not so familiar with the procedures, I kind of rattle through it fairly quickly as to what's involved in all the different types of procedure. But if you go back to the Code of Practice, which I mentioned in item 4, I think, if you read that, it's got quite a bit more, and it sort of annexes to that a bit more information as to what happens at an inquiry, what happens at a hearing session. It gives you an idea of the sort of commitment that's involved. I mean, I'm really obviously talking to third parties here, local people. Mr. Campbell obviously will be able to help you on that as to what sort of time commitment you need to give, and deadlines. It can all come upon you quite quickly as to when you need to have got certain documents in, and it's certainly our Code of Practice doesn't appreciate delays of putting in evidence late or documents late or last minute changes and things. So the idea is to front load everything. But it is quite, it's a hefty commitment. But as I say, that's a lot more onerous for professional witnesses appearing at an inquiry session than it is for somebody wishing to simply come along to the evening session to explain their own personal views. But still, there's a need for prior notice of what they intend to say, so it's fair to everyone. I think I've got to do everything I was going to say. Was there anything, anyone else? If I start, Mr. Mackay, I'll start with Mr. Mackay and we'll go around as before. Anything I haven't covered?
No, that's everything. Thank you very much, sir.
Mr. Carroll?
I'm sure you've already covered it, but I think I wondered if you could give an indication of the 3 different stages that will follow. In the old-fashioned parlance, you'd then be looking at a statement of case from the principal parties, thereafter a date for documents and a date for precognitions. And I think it might be helpful if we could have an outline of those today, if you're able to do that. Yeah. The other thing I wanted to raise, though, was, again, you've mentioned the Objective Connect. Can I understand then that that is what you'd anticipate being the central source of documentation as opposed to the DPEA website?
I believe so. I was given notice of this on Wednesday, and I should have asked more questions, but the lady, Ms. Cowie, who's the case officer, she doesn't work at the end of the week, so I'm not entirely sure of what it entails, but I believe the idea is this Objective Connect space dedicated for each case, and that will be the sort of the official repository for all documents.
Okay, understood. Thank you very much.
Probably understand.
It's just that in the past it's always been the DPA website, but I understand that. But the final thing I wanted to say was that in other inquiries, the applicant has undertaken to provide memory sticks to the other principal parties of all of the documents. And I have found that to be extremely helpful. In particular, was that the Sheer Drim inquiry, and the memory stick that was provided was exemplary in how straightforward it was to use. And I wondered if perhaps the applicant could undertake to do that in this case, so that we have the final word of all of the documents by way of memory stick to everyone, rather than leaving it to individuals to download it on their own memory sticks. Perhaps it might not be as efficiently done as one might expect professionals to do it.
Yeah, understood. Mr. Mackay, your client amenable to that?
In principle, of course, sir. It's just really the practicalities and any IT issues that might arise or security issues. It may also depend on the source of the documentation as to how it's downloaded, for example. And I think it'd probably be useful to just understand a bit more about how documents are to be managed and therefore how they're to be accessed, but certainly in principle, we should be able to assist.
Thank you. That's helpful. I will include within the note, once I've spoken to the person who knows what they're talking about, how it will all work. I think she's back on Monday, so all will become clear, I hope.
I should say that I don't envisage any documentation from the Wayleaves being published to that degree of as part of the Objective Connect suite.
No,
I think we'll just keep them
it's more for private.
and their own flavor.
Right.
And the normal rules that would be applied about publicity and everything they'll be on the DPA website as in a sort of more traditional manner.
Right, Mr. Campbell.
Thank you. We're a bit spoiled for choice with possibilities of getting the documentation in front of us, but of late, large solicitors firms, and I assume large utilities like SSEN, have provided the documents on an intranet so that with passwords one can access those externally without using a USB stick. There is concern nowadays about security issues with USB sticks, which I don't know if they're real or not, but nevertheless, I've heard them. Using an intranet, as happened with the KTR project and has happened in 1 or 2 wind farm inquiries, is very efficient. It also means that one person is doing the document labeling so that they're identifiable by a prefix as to their source, and that can be very helpful too if there's a large number of documents. I know Miss Anderson is a professional researcher, and no doubt she has her own view, but I don't know if Mr. Mackay's clients have that facility. They may not. But I just mention it for whatever it may be worth.
I'm just going to interject slightly because I'm actually a qualified librarian and I work in research publishing now. Objective Connect is kind of like an intranet. It is a secure document storage that gives everybody a version of record of each document. In a way, it is more secure than a memory stick because John Campbell is correct. A memory stick is an insecure method, and it also means that there could potentially be multiple versions of things. Objective Connect is a really good solution because it is basically an intranet or a secure Dropbox for anybody that doesn't appreciate that. But it means that every time someone downloads something, it is the version of record, and it is everybody's working to the same thing.
Can I ask a question then, technical question that you or others may know the answer to? Is if you do use that function to download and you store it on your device, whatever that might be, does that mean you're not reliant upon Wi-Fi connection at the venue itself to be able to access the document?
Yeah, absolutely. Right. And it means that you can print, and it means that you're absolutely guaranteed that the version of the document that you're looking at is the most up-to-date document. I would advise everybody, and I probably shouldn't advise everybody because we're on opposite sides. My professional advice is that if you download key documents, make sure you just double check there's not a new version again closer to the time. Because whatever is on Objective Connect will be the version of record. So if there's any updates, it goes on there.
Sounding like in an ideal world, we'd all have live access to the official Objective Connect source at the venue, but that would depend on how good the internet is. So maybe our IT people can talk to the venue and try and work out if that is an option. As Mr. Campbell said, that has worked before. Where we've had a venue with good Wi-Fi and good broadband, and so you can be absolutely sure you're all looking at the same document rather than one that's become superseded in the last few days. But it might be that either the applicant or parties individually will have to, the night before or whatever, just take a download copy just to make sure that if anything goes wrong with the internet, we've still got something to look at on the day. But I'll make some inquiries to how best to sort it, because I'm no expert by any means. Going back to Mr. O'Carroll's question about sort of timing, we've got a bit more time than I'd feared. So, I mean, usually I would say counting back from kickoff, recognition's 4 weeks, but I'm pretty flexible on that, and documents a couple of weeks before that. And then in terms of the initial statement of case or whatever you call it, I would usually set something running from the date of the responses to the notice of this meeting. So that will be 14 days from next week. So we'll know who's coming, and then X weeks after that, parties should, put in their sort of outline statements. I'll need to sort of look at the.
You presumably want to set a date for me to provide you with an outline of the case on need.
Yeah,
reasonably quickly.
Please.
Unfortunately, I've tried to speak to my expert, or my putative expert, just now, but he's not. He's not available at the moment, so I can't speak to him. I would have thought 2 or 3 weeks, subject to Mr. Mackay's comment, perhaps, would be reasonable.
You can say
that would be really helpful, and I think also as part of that exercise, if it's possible, if to give as much clarity as you can about the main alternatives that you want to be the focus of the hearing session on alternatives, because as you understand, with such a complex routing exercise, there are many alternatives that have been considered over quite a significant period of time. And on the issue of alternatives, just coming back to a comment Mr. Carroll made earlier, where he said that his planning consultant may want to be present at the hearing sessions in relation to alternatives, and I think possibly if there is one in relation to the technical need as well. Just for clarity, I think it'd be useful to understand that would be as an observer, not a participant. In other words, to inform his evidence on the policy issues, having regard to the fact that the council's objection is limited in scope.
Yeah.
Well, I understand that point in principle, and I'm well aware of that. I have discussed that with him. Still have to fully scope out the extent of his evidence, but I understand the principle, and yes, that is going to be it. I can't simply enlarge the case beyond the one of the scope of the objection originally at the actual hearing itself.
Yeah.
Good. Anything else? I may have asked that already. Anything I've forgotten to ask? Anyone want to say anything before we go? No? Okay. Thank you very much. And be in touch next week with hopefully a bit more clarity as to where we're going. As any questions arising out of that, do get in touch with me via the office. But particularly for those who are less experienced, make sure you don't miss the boat in terms of lodging your intention to participate if that's what you want to do. And there'll be a deadline for that, which I think is 14 days. But thanks all.
Thank you.
Have a good weekend. Bye-bye.
You too.